I firmly believe, and all of you have told my team and I, that it's absolutely the right thing to focus on enhancing patent quality, specifically correctness and clarity.
Welcome back to AIPLA TV, sponsored by Jameson. The first full day of the annual meeting was filled with opportunities to connect, collaborate, and learn the latest breakthroughs in IP standards, laws, and policies. And it all started with a conversation with one of the most powerful voices in patent and trademark. The Honorable Michelle Lee, Director of the USPTO, discussed her priorities for the agency, which include timely issuance of high-quality patents and ensuring that Patent Trial and Appeal Board conducts fair proceedings and issues high-quality and consistent rulings. She also discussed the work she's been doing to make meaningful improvements to curtail abusive patent litigation. Lee also offered insight into her internal initiative to expand opportunities for women in STEM.
So I have the privilege and honor of being the first woman Undersecretary of Commerce for Intellectual Property, and it's an honor and a privilege. But I do feel a heightened obligation to help and give opportunities to young girls. There aren't enough girls who enter in the science, technology, engineering, and math fields. There are not enough women who enter the profession, stay in the profession, and move up the ranks. And as a matter of economic necessity, we cannot compete in a global economy if we're not taking advantage of all of our talent.
On Thursday, we also recognized the recipient of the AIPLA Excellence Award. Judge Richard Lynn was honored for his years of service to IP and to the AIPLA.
I've seen this organization grow over the years as the field of intellectual property has grown over the years. And to be recognized today by this organization in this special way is just very, very meaningful to me. It's humbling.
Another benefit of attending the annual meeting is the comprehensive CLE programming. The annual meeting has a total of 825 CLE minutes, including 135 minutes of legal ethics. In this interactive session on patent litigation, a panel of speakers discussed induced infringement, means plus function claiming, and claim construction based upon Federal Circuit and Supreme Court precedent and how that could impact our practices.
I thought it was interesting how they were talking about intrinsic and extrinsic evidence. I've never really thought about that, but evidence is a key element of any type of patent litigation, so it is interesting how that's in dispute right now.
There's a lot of volatility, I think, in the courts on this, and that it's important to put as much evidence in at the trial level, so let's see what happens at the appeal stage.
Panelist Scott Pivenick believes that in the future, practitioners will have to find more creative ways to convince district court judges in the federal circuit that expert testimony is important to the claim construction.
I hope for all three of the speakers that we kind of imparted some knowledge that would allow them to then better focus their practices. I mean, that's why I come to AIPLA meetings, is to find out what's happening in the world. I don't always have the time to do the research on all these cases. So we tried to get them to learn from us, and that's what I'm hoping to get out of this whole meeting as well.
In this packed track on trademark and copyright, panelists discussed the Oracle versus Google litigation, which originated in the Northern District of California, in which Google tried to take all the way to the Supreme Court. Panelists presented on the issues implicated in the case. One thing that they all agreed on was that the litigation itself would be going back down to the district court for fair use trial.
I think that the really salient point of agreement among everyone on the panel and the audience is this stuff is complicated, right? The law of software copyright has always been a bit baffling, even to practitioners of copyright law. Some of us think that, the cases on these issues are, reconcilable to some degree.
In between sessions, attendees got a first-hand look at the latest products and services in IP here in the exhibit hall. This year's exhibit hall features more than 40 companies. One of those companies was AIPLA TV sponsor, Jameson.
It's a perfect opportunity for us to meet with law firms and individuals in the community so that we can really provide a more robust product with regards to legal malpractice and risk management services to IP attorneys and IP law firms. Certainly they would want to come to find out more about the products that Jameson has to offer. It's not just legal malpractice and insurance policy. There's a vast array of risk management services and a number of other ancillary products that we provide.
The AIPLA has a reputation for delivering some of the most dynamic speakers, and on Thursday, the Honorable Judge Alan Lourie provided some midday motivation.
As practitioners, your membership knows more about what the law should be than any court, and you should make your voice heard.
Judge Lourie opened up about his career in IP and the changes he's seen in the court over the past 25 years. He urged AIPLA's premier group to take a stand in areas where laws needed to be changed.
My advice to these people, most of whom are young, is to work hard and do well and keep your eyes open. It's a very interesting field as it is. If one is looking for something else, the best thing to do is to do well at what you're doing and survey the world.
PTAB is where all the action is right now, and this session on the evolution of PTAB is where many attendees spent their afternoon. The overflow crowd listened in as the lively panel discussed the interplay and strategy of what you would do in district court versus PTAB, and well-established tactics that are likely to continue.
One of the biggest ones right now is the popularity of the optional patent owner preliminary response after the petitioner files their petition. That's definitely extremely popular. It will remain to be so. The new rules also may afford the patent owner an opportunity to attach testimonial evidence to their preliminary statement.
One of the challenges that we've got with the PTAB proceedings these days is we need some guidance. It's brand new. You've got a blank sheet of paper, and having the Federal Circuit help the bar and the PTAB understand how these proceedings should be construed and should be implemented is really an important set of issues, and I thought the speaker did a good job.
Well, that's it for day one. We encourage you to keep the conversation going on social media. Be sure to use the hashtag AIPLAAM15. For now, I'm Rhonda Craig with AIPLA TV, sponsored by Jameson. Thanks for joining us.